Hello all, welcome. The today's is second topic of civil procedure code. In these are exam topics which are left. The exam topics are procedure for institution of suit by and against minor and person of unsound mind, law relating to suits by indigent persons, free legal aid, suit against government, decree, essential elements, decree and order, limitation and general principles of limitation. Coming to procedure for institution of suit by and against minor and person of unsound mind. Minors and persons of unsound mind are persons that can be easily exploited due to their mental incapacity, anticipating that they might be cheated, ill-treated, or trapped in a fraudulent device. There are several provisions to ensure their protection. Order 32 of CPC 1908 contains special provisions applicable only in cases where either the suit is to be instituted at the cause of minor or person of unsound mind, to be instituted against a minor or person of unsound mind. Who is a minor? Who is a person of unsound mind are discussed here. A minor is, for the purpose of civil litigation in India, defined to mean a person who is not attained majority under the provisions of the Indian Majority Act 1875, and that is a person who is not completed the age of 18 years. And in case of a minor whose person or property a guardian has been appointed by a court or whose property is under a court of words, a person who has not attained the age of 21 years. A person of unsound mind, a person who is declared after competent examination to be unable to understand the nature and consequence of his actions due to the presence of a mental disease or infirmity. Others are, according to Rule 1 to 14 of Order 32, apply not only to minors and persons adjudged to be of unsound mind, but also those who are found to be by a court upon inquiry to be incapable by reason of any mental infirmity of protecting their interest when suing or being sued. Let us see the concept of next friend or guardian. The object behind having a next friend or guardian ad litem is that a minor is deemed to be incapable of defending himself, and therefore it is imperative that his interests in the suits should be supervised by an adult person. This person, in case of a minor, is a plaintiff to be called as a next friend, and when the minor is a defendant, it is called as a guardian ad litem or guardian for the suit. However, neither the next friend nor guardian ad litem is a party to the suit. Coming, who is a guardian to the minor. Every suit by a minor should be instituted in his name through his guardian or next friend. If the same is not done, the plaint will be taken off the file. A person who has attained majority and is of sound mind may act as a guardian or next friend, provided his interest is not adverse to that of minor, who is not the opposite party in the suit and who gives consent in writing to act as a guardian or next friend. That means a guardian who can be as a guardian who attained majority with sound mind and who is not in the opposite party and who gives consent in writing. In absence of a guardian who is fit and willing person to act as a guardian, the court may appoint any of its officers as guardian in that particular suit. Rule 6 and 7 gives safeguarding the minor. By way of Rule 6 and 7, without the leave of court, no guardian or next friend can receive any amount or movable property on behalf of minor, can enter into any agreement on behalf of the minor, cannot reach any sort of compromise in the suit on behalf of the minor. The guardian must apply for leave of the court in all of these above cases, and the application must be accompanied with pleader's certificate and affidavit. The rules 6 and 7 have been designed in order to safeguard the interest of a minor during the pendency of a suit against hostile, negligent, or collusive acts of next friend or guardian. When minor attains majority. When a minor attains majority, he can choose either to proceed with a particular suit or to abandon it if he had moved the court through a next friend or guardian. Therefore, when he elects to proceed with the suit, he must apply an order from the court discharging the next friend or guardian and for leave to proceed with the suit in his own name. Where he elects to abandon the suit, he must apply for dismissal of suit and repayment of costs of defendant or next friend or guardian as the case may be. When the minor co-plaintiff desires to repudiate the suit, he may repudiate the suit and apply to have his name as co-plaintiff struck off. When the minor desires that suit is instituted in his name to be dismissed on the ground that it was unreasonable or improper, he may by application move the court for dismissal of such grounds. Case laws: Ranganathan Chettiar versus Perrakariyappa Chettiar, where the mother was allowed to bring a suit concerning certain properties to be inherited by her and her minor son, which had been wrongfully claimed by the brother of the deceased husband. In Ramchandra versus Mansingh, it was held that a decree passed against a minor or a lunatic without appointment of a guardian is a nullity and void, not merely voidable. Law relating to suits by indigent persons, that is free legal aid. Under Article 39A of Indian Constitution, that protects the interest of vulnerable segment of the society, it provides free legal aid to the poor and weaker sections of the society and ensures justice for all. Besides Article 39A, Article 14 and 22(1) of the Indian Constitution provide that it is obligatory on the part of the state to ensure equality before the law and provide a legal system that aims at promoting justice. Who is an indigent person? Order 33 of Civil Procedure Code talks about suits by indigent person. Indigent person means poor, destitute, and pauper. A person is a needy person who does not have sufficient funds to pay the lawsuit fee, or if such fee is not required, he is not entitled to property worth 1,000 rupees, but their properties which are attached in the execution under section 60 will be exempted. The property which will be exempted are from attachment in execution of the decree. Subject matter of the suit shall be excluded. Coming to legal aid. In India, indigent persons are helped by Legal Services Authority to achieve justice. Legal Services Authority. There are three levels of Legal Services Authority in India established under Legal Services Authorities Act 1987, namely by the center that establishes National Legal Service Authority (NALSA), which in turn establishes the Supreme Court Legal Services Authority, that is SCLCSA. State that establishes State Legal Service Authority, hereafter SALSA, which establishes the High Court Legal Service Authority and District and Taluk Legal Services Authorities. Legal aid offered by legal services authorities. The free legal services entail the provision of free legal aid in civil and criminal matters to those who are poor or marginalized and cannot afford the services of a lawyer to conduct a case or a legal proceeding in any court, tribunal, or authority. The services of legal service authority includes payment of court fee, process fee, and all other charges payable or incurred in connection with any legal proceedings are examples of free legal aid. In legal proceedings, obtaining and delivering certified copies of orders and other documents. In legal proceedings, preparation of an appeal, a paper book, including printing and translation of documents, performing any service in connection with the conduct of any case or other legal proceeding before any court, authority, or tribunal, giving legal advice on any subject. Person eligible for free legal aid. Section 12 of the Legal Service Authorities Act states that the following persons are entitled for free legal services: women and children, members of scheduled caste and scheduled tribe, industrial women, a victim of trafficking in human beings, or beggar, are as referred in Article 23 of the Constitution, Victims of mass disaster, violence, flood, drought, earthquake, industrial disaster. A mentally ill or otherwise disabled person in custody or in a juvenile home or in a psychiatric hospital. Persons whose annual income is less than 9,000 or such other higher amount as may be prescribed by the state government if the case is before a court other than the Supreme Court. In case of Supreme Court, the amount will be less than 12,000 or such other higher amount. Case laws. A. Haja Muniuddin versus Indian Railways. The court held that access to justice cannot be denied to an individual merely because he does not have the means to pay the prescribed fee. In Union Bank of India versus Kadir International Construction, this court has held Order 33 CPC is an enabling provision which allows filing of a suit by an indigent person without paying the court fee at the initial stage. If the plaintiff ultimately succeeds the suit, the court will calculate the amount of court fee and that amount would be recoverable by the state from any party ordered by the decree to pay the same. Suit against the government. The suits filed by or against the government or public officers in their official capacity is covered under Part 4 of Code of Civil Procedure. The procedure of filing such suit is covered under Section 79 to 82 of the Code and Order 27 of the Code. Coming to Section 79, whenever a lawsuit is brought against the government or by the government, the plaintiff and defendant will be called as follows. The Union of India will be represented as the appropriate plaintiff or defendant if a case is brought by or against the central government. State government would be allowed to serve as a plaintiff or defendant in any suit brought by or against the state government. Bulumujumdar versus Department of Post Office, where the Superior Court set aside the lower court judgment just because of the fact the party name of the Department of Postal Services was not properly instituted. The court must check the party name irrespective of the fact whether it has been claimed or not in the written statement. Section 80 of the Act. Section 80 of the Act, which talks about the 2 months notice to the concerned departments before the institution of the suit, makes the procedure of filing a suit in case of public officers or government a unique and complicated one. The Section 80 talks about the time period. Suras versus SDO Delhi, it was explicitly stated by the court that the provisions and procedure mentioned under Section 80 and 79 of the code is mandatory and not discretionary in nature, and thus if a notice is not sent or if the government is not impleaded as a party to the suit, such suit is liable to be dismissed and there shall be no hearing to that accord. Section 81, 82 and Order 27 says Section 81 saves a public officer from being arrested or his properties being attached unless and until adjudged by the court in way of decree. This is added to safeguard them from being subjected to humiliation from public either by vexation motive or personal vengeance. Section 82 of the Act speaks about the execution of a decree passed against the government and the procedures thereto. Order 27 includes, under its ambit, various rules and subjects like that of recognized agents, Attorney General, and the procedure to be followed while the suit is being filed by or against the government or public officers in their official capacity. Contents of the notice. This provision was misused by the government party, dismissing the case on ground of technical defects in the notice. In the Supreme Court judgment of Amarnath versus Union of India, the court clarified that notice under Section 80 is not to be construed on the lines of plaint, but however, it should have the following ingredients: name of the parties, address and description of the plaintiff, description of the suit property, cause of action, and relief sought after. Coming to the next topic, decree. A decree is one of the most frequently heard terms in civil matters. The adjudication of court of law is divided into decree and orders. The term decree has been defined under Section 2, Rule, Rule 2 of the Code of Civil Procedure 1908. The decree is a formal expression of adjudication by which the court determines the rights of parties regarding the matter in controversy or dispute. Essential elements of decree. The decree is a decision of the court. For any decision of the court to be decree, the following elements are required. There must be an adjudication, that is, a formal decision of the judge on the matter in dispute. The adjudication should be done in a suit. It must determine the rights of parties regarding the matter in dispute. The determination of their right should be of conclusive nature, and there must be formal expression of such adjudication. Classification of decree. The decree may be classified into preliminary decree, final decree, partly preliminary and partly final decree, deemed decree. The preliminary decree is a decree where the court decides the rights of the parties relating to all or any of the matter in the controversy but does not dispose of suit finally. Final decree. When the court decides all the matters in the controversy and finally disposes of the suit, it is called final decree. Partly preliminary and partly final. Partly preliminary and partly final decree are those where a final decision has been passed in respect of a part of the suit and other part is left for future adjudication. Deemed decree. There are certain orders which are considered as deemed decrees under Civil Procedure Code, such as adjudication under Order 21, Rule 58, the Rule 98 and Rule 100 are deemed decrees. Similarly, rejection of plaint and determination of question under Section 144 is a deemed decree. Decree holder. Section 2, Class 3 of Civil Procedure Code provides that a decree holder is a person in favor of whom the decree has been passed or an order which is capable of execution has been made. A decree holder can be any person. Coming to the differences between order and decree. Decree is passed only in a suit which is commenced by the presentation of the plaint. An order can be passed in a suit instituted on plaint as well as from a proceeding commenced on a petition application. The decree determines the right of parties in dispute conclusively. An order may or may not finally conclusively determine such rights. A decree can be preliminary or final. An order cannot be preliminary. In a suit, there can be only one decree except for the suits where a preliminary and final decree is passed. A number of orders can be passed in a suit or proceeding. Every decree is appealable unless expressly provided. Only the orders specified in this code are applicable. Second appeal lies to the High Court against the first appeal of a decree. There is no provision of the second appeal in case of appealable orders. Coming to difference between judgment versus decree. Judgment is the statement of the judge on the ground of a decree or the order. For decree, a statement of the ground is not required to be given by the judge. The judgment does not require to have a formal expression. A decree must be a formal expression. The relief granted is required to be stated preciously in the judgment. A decree determines the rights in the dispute between the parties. A judgment is passed in a stage prior to passing a decree. A decree is passed after issuing the judgment. The judgment is pronounced in civil as well as criminal cases. A decree can be passed only in civil suit. Coming to case laws, in Madan Nayak versus Hansubala Devi, the Supreme Court held that if the matter is not judicially determined, it is not a decree. In Narayanan versus Lakshmi Narayanan, the court held that the court may pass preliminary decree in a suit not enlisted by the code. In Dhaniram versus Lala Sriram, the court held that a person who is not a party to the suit but in whose favor a decree has been passed or an order capable of execution is made shall be the decree holder. Coming to the last topic, limitation and general principles of limitation. The word limitation itself says the meaning. The word limitation in its literal term means a restriction or the rule or circumstances which are limited. The law of limitation has been prescribed as the time limit which is given for different suits to the aggrieved person within which they can approach the court for redress or justice. It means that a suit brought before the court after the expiry of the time within which the legal proceeding should have been initiated will be restricted. The object of the Act. The law of limitation prescribes a time period within which a right can be enforced in court of law. The time period for various suits has been provided in schedule of the Act. The main purpose of this Act is to prevent litigation from being dragged for a long time and quick disposal of cases which leads to effective litigation. According to Section 2J of the Limitation Act 1963, the period of limitation means the period of limitation prescribed for any suit, appeal, or application by the schedule. Prescribed period means the period of limitation computed in accordance with the provisions of the Act. Limitation bars remedy. Section 3 lays down the general rule that if any suit, appeal, or application is brought before the court after the expiry of the prescribed time, when the court shall dismiss such suit, appeal, or application as the time barred. The law of limitation only bars the judicial remedy and does not extinguish the right. Hence, the original right to suit is not barred. Hence, the Section 27 is an exception to this rule. The limitation does not bar defense. The law of limitation does not restrict the defendant if he raises a legitimate plea in his defense, even though the suit is time barred. It was held in Ruliaram Hakiram Rai versus Fateh Singh. The bar of limitation does not stand in the way of defense. The Supreme Court observed in Srimad Shamrao Suryavanshi versus Prahlad Bhairova Suryavanshi. The Limitation Act takes away the plaintiff's remedy to enforce his rights by bringing an action in a court of law. Plea of limitation. Duty of court. The court is under an obligation to dismiss a suit if it is filed beyond the time prescribed by the Limitation Act. The provisions of Section 3 are mandatory and the court will not process with the suit if it is barred by time. Under Section 3 of the Act, it is clearly mentioned that every suit instituted, appeal preferred, and the application made after the prescribed period shall be dismissed, even though the limitation has not been set up as a defense. Condonation of delay. The condonation of delay means that extension of time given in certain cases provided there is sufficient cause for such delay. Section 5 talks about the extension of the prescribed period in certain cases. It provides that if an appellant or the applicant satisfies the court that he had sufficient cause to not prefer the appeal or application within that period, such appeal or application can be admitted after the prescribed time. Case law. Balwant Singh, who is late Balwant Singh versus Jagdish Singh, the Supreme Court held that it is obligatory upon the applicant to show sufficient cause because of which he was prevented from continuing to prosecute the proceeding in the suit. In this case, there was a delay of 778 days in filing the application for bringing the legal representatives on record. The landmark judgment has come from Collector versus Khatiji. The facts are, in this case, an appeal was preferred by state of Jammu and Kashmir against the decision of enhancing the compensation in the matter of acquisition of land for a public purpose, raising important questions with regard to principles of valuation. An appeal for condonation delay was filed but was dismissed by the High Court as time barred because it was 4 days late. The state later appealed to Supreme Court by special leave. The Supreme Court held that it allowed the appeal and ruled that the expression sufficient cause under Section 5 is adequately elastic to enable the court to do substantial justice to parties. The order of the High Court dismissing the appeal as time barred was set aside and the matter was remitted back to the High Court to dispose of the appeal on merit after affording a reasonable opportunity of hearing to both sides. Exception to Limitation Act. The Bhopal gas tragedy, as everyone knows about Bhopal gas tragedy, which was we are talking from the first year, is Union Carbide case. In this, the Bhopal Act under Section 8 provides that if a claim is registered under the provisions of this Act, then the provisions of Limitation Act shall be excluded. The Bhopal Act under Section 11 has an overriding effect over any other law inconsistent with this Act. Hence, the Union Carbide case serves as an exception to the Limitation Act, for it excludes the Limitation Act 1963 for the purview of the Bhopal Act 1985. All the best for all people. Thank you. Please like, share, subscribe.